I'll say in my experience, when it comes to trials and when it comes to discovery, especially if you have good representation, the truth oftentimes comes out. And I don't want to make too broad of a statement. I mean this especially when you have two good lawyers, right? On both sides, the truth oftentimes comes out. Although, as you said, there could be an example of somebody not who's legitimately a victim of abuse who doesn't cross their I's, doesn't dot their T's, or vice versa, and looks really bad at trial, even though they're telling the truth. But I mean, one thing that I've noticed there's on TV especially, and there's kind of this perception in society that if you have a really good lawyer, they can do some kind of magical sleight of hand and win any case for you. And oftentimes that's not the truth. That's not
Well,
the
yeah,
case.
a really good lawyer, their magic trick and sleight of hand is mastering the facts and knowing more than the other side. Like
Mhm.
when I go into trial, I want to be the guy that the judge and the jury, in the case of restraining order, the fact finders, the judge. I want everybody to be like, okay, he's got all the answers because he's anticipated. That's a function of obviously knowledge and subject matter expertise, but also preparation. And a lot of folks going through the restraining order process, they can only afford a lawyer to go to court with them that doesn't have the time to go through all that. That's why it's incumbent upon the litigant, the petitioner or the respondent, to learn these things on their own so they are prepared. That's the only way to mitigate against that risk, the uncertainty of trial, of having a lawyer look like they're doing magic tricks when in actuality they're just saying objection, hearsay, and all of a sudden all those letters you brought into court that say that they saw this happen are crushed and you're left with nothing.
The judge can't even consider them.